Hi, everyone. I'm Ritu Singh. I'm president of the SABA North America Foundation. We're an organization with a mission to support access to justice through grant making and educational programming by fostering collaboration among nonprofit organizations serving South Asian communities in North America and by advancing causes important to the communities we serve. And with that, we're very happy to present our last learning lab of this year, 2023. Happy holidays of Know Your Rights, the intersection of immigration and domestic violence. This learning lab is sponsored by Spencer Fain, and we thank them. And presenters Kalpana Peddibhotla of SABA Foundation and Zakia Afrin of Maitri are going to be presenting on this topic. And so with that, I'm going to go ahead and pass it on to them. So Kalpana, I will go off screen and it's all yours.
Thank you so much. Hi, everybody. Let me see. Thanks for having us. As Ritu mentioned, I'm an immigration attorney, and I'll be talking to you today about the intersection of how to use immigration laws to support survivors, and also what the issues are that they may confront. And then Zakia is joining me from Maitri. We're both here on the West Coast, and the two of us have worked together for quite some time. Maybe what I'll do is, Zakia, I'm going to just share my screen, get our PowerPoint going here, and see if that works. Okay, there we go.
Thank you, Kalpana. And I actually put in the chat for people while they wait for us to begin, if they can share their agency affiliation and favorite holiday, since we are getting into the holiday mood.
Sounds good. All right, there we go. Sorry, my slides were just a little delayed. I hope everybody can see our slides up here. We plan to share these with you all after today's learning lab. This gives you a little bit of details about Zakia and myself. We have 1 hour, and in this time, we understand we're not going to be able to explain everything there is about immigration law and domestic violence, but what we're trying to do today is give you at least an overview of the challenges faced by immigrant women in particular in domestic violence circumstances. So I think we'll start with Zakia. Zakia, first, can you talk to us a little bit about Maitri and the work that you've been doing with South Asian immigrant women?
Thank you, Kalpana. As many of you know, this is a very important topic for all the advocates and attorneys to understand, because domestic violence is so pervasive in our communities. And we also live with a large number of immigrant population. So the intersectional issues are truly very important for us to appreciate, so that we can prepare ourselves when we are serving our community members. I work with Maitri, this agency, for the past 17 years. I have been associated with this organization. We began as a helpline in 3 friends in their kitchen, like many other technological innovation stories that you hear. People start from their garage, and Maitri literally started from the kitchen of 3 friends. They were pick calls from immigrant women who needed help with their situations at home, but did not feel comfortable or did not have access to the mainstream services at that time. We're talking about back in the 1990s. And in the California Bay Area, there are many agencies working even from before then. But what we saw, that there was a gap of culturally responsive services for individuals coming from South Asia. And that's how Maitri began offering specialized services for South Asian individuals experiencing domestic violence. And over the years, we have grown depending on the need of our community. Right now, we have our helpline program, our legal program, where we are able to help people begin and complete their divorce process, child custody related issues, paperwork that's needed for any kind of family law paperwork. We have a housing stabilization. We have a transitional housing program for people when they're out of a shelter emergency situations. We have an economic empowerment program that provides basic financial literacy education and career readiness for somebody who may have just come into the country and have not learned the ropes yet. In terms of policy advocacy, we figure out some of the priorities that are very close to serving immigrant survivors. For example, language access, immigration-related matters, criminal justice reform, and we do advocacy in different types of activities. Now, obviously, our big goal, vision is to transform the community with prevention and awareness campaign so that we can stop domestic violence from happening at the beginning. I also want to take just one moment more to talk about our immigration program. Back in 2011, Maitri became Department of Justice recognized agency to provide representation for domestic violence victims and survivors. Currently, we have 2 staff members that can represent clients with their immigration benefits application. And I have been representing survivors since 2011 now with multiple immigration-related benefit matters. So that's a little bit about the agency. I can go on, but I'll move on. In terms of what do we do with the immigrant survivors. Now,
So I've known Maitri since about 1991 as well. And I mean, the comprehensive services you guys offer are just phenomenal and definitely a model for other organizations, I think, to aspire towards. So thank you so much for all the work that you guys have been doing for decades now. And I think what's important as to why does Maitri exist, it comes out of this context of, you know, the unique issues that South Asian communities in particular face in both in terms of domestic violence and then that intersection with immigration status. So Zakia, I hope I didn't cut you off earlier, but could you maybe speak to this in the South Asian context?
Yes, thank you, Kalpana. I have been, like I mentioned, I've been working with Maitri for a long time, and honestly speaking, every single day is a fulfilling learning experience for me, and I truly appreciate the amount of services and the networks that are around for us to take benefits from. And one of them I must mention, Kalpana, you have been such a great resource for us when we wanted to learn about an immigration benefit, when we needed somebody to come and talk to our volunteers, giving them the big picture scenario. You have always stepped in. So thank you very much for that. I see that in the audience today, we have many advocates. So of course, we all understand what domestic violence is. We understand that it's a pattern of abuse, pattern of coercive controlling behaviors that can include physical, emotional, sexual, financial, and psychological abuse by one partner to another. And in the South Asian context, of all of these elements are there. And we also find a very specific barrier for survivors and specific tools of abuse that many of the perpetrators use, which is related to immigration. Now, when a survivor is also has an identity as an immigrant in this country, there are many other dynamics they're trying to deal with. And how does that show up in a relationship that is not equal, that is not really healthy? How does it show up as abuse? The person may not be able to have any kind of resources at their disposal. They may not have a place to share what they're going through. They can have doubts about the rights they have in a new country. They may not be allowed to work. And all of these issues can be used against a partner who is already going through abuse because they are not sure what rights they have, who is ready to help them. And bring into this the complexity of the international nature of family law structures, the nature of child custody that works in this country. A person may not be aware about how the family law system also work and what happens if they talk about domestic violence to an outsider. So all of these issues can literally weigh down a survivor and hamper whether they will choose to ask someone for help or not. And as an agency that is focusing on South Asian individuals, we have seen that in the past 31 years, one of the first things we try to convey to whoever is calling us is that yes, everything is confidential, everything is non-judgmental, but also to understand that just because they're survivors, there is nothing stopping them from getting help about that situation that they're in. So now I think this is a good time for me to ask to Kalpana that, people call us. Last years, we had more than 700 people reach out to our agency, and almost half of them had issues related to any legal matters, and majority of them had immigration-related concerns. So my question to Kalpana is, when a victim or survivor comes to you, many times we are referring them, other agencies are referring them, or they're finding legal help for themselves. What are some of the concerns they share, and what do you tell them?
Sure. Sorry, I'm having a little glitching with my PowerPoint, so I'll come back to it in a minute. I think the main thing as a lawyer and as an immigration lawyer is to give the client reassurances, right? So there's, through the course of surviving their domestic violence circumstances, a lot of what they may have been told before reaching the lawyer's office is that they've been told that they're going to get deported. Their abuser threatens them with deportation. They threaten them that they'll tell USCIS that the marriage is fraudulent. They tell them that because of their immigration status, that they get deported and they can't have they won't be able to keep their children, right? So these are things that happen by the time that they've reached the immigration lawyer's office most. So as an attorney, I think the number one thing is to first address that fear up front, acknowledge that fear, but also give them the reassurance that those threats are just part of the pattern of abuse by their spouse, and that they are not going to get deported. That their status, immigration status, is not even considered by a family court. It's not allowed to be considered by a family court. And truthfully, USCIS itself is aware that these are tactics that there's abusive spouses use in claiming that there's fraud in the marriage, because they're always scared of that. Like, they're going to call USCIS and say that, and it's important to dispel them of that belief that that's actually not what they're able to do, that those calls are taken. Essentially, USCIS recognizes this pattern as well, and that they're not ones that we should give weight to. So that's where I start, is first start with these reassurances. And then we can start talking about what possible remedies they might have available to them under immigration law. Zakia, give me a second. Let me see if I can get this screen up again, because we have a beautiful PowerPoint and would hate for us not to be able to use it today just because it's glitching on my side. So I will try to share screen one more time and see how this works. All right, I think we're here. Hopefully everybody can see my screen again. So we're talking about now, what are the protections people might have? There's a lot over here to go through, and it's unrealistic for us to go through all of this in detail. So what I wanted to share today is that there are protections for survivors under U.S. immigration law. Let's start there. There are protections. There are affirmative applications that people can make in order to seek those protections under our laws. Some of these terms, if we have many advocates on the call, I'm sure that we may have heard of these terms before. So I'll just, and at the very end of our slides, we actually have an appendix of the requirements for each of these different applications. So I won't be going through all of that today. I'll just highlight what these protections are. So the Violence Against Women's Act was modified at least 3 times with respect to immigration protections, and each time they broadened those protections. So the first one was to protect the spouses of U.S. citizens and green card holders so that they can file for a self-petition for the green card by establishing that there was abuse in that marriage. The important things about that first one, the VAWA, under VAWA, is that it does not require a police report. Though it may be helpful, it's not a requirement. The second one, which came many years later after VAWA was initiated in, I think, the early 90s, is the U visa, which came about in the 2000s. And this is a temporary visa for the spouses of certain non-immigrant visa holders, including H-1Bs. Typically, you do require a police certification, but I want to note, while we're not going into in detail today, it is not a requirement that you have to get a certification from a police department. You can actually get through a family court proceeding in domestic violence, where the family judge makes a finding, usually during a restraining order hearing. If there's a finding of domestic violence, that family judge can actually issue that certification for a U visa. T visas are for trafficking matters, and then more recently, the I-765V, which doesn't give people status, but it does give them employment authorization. Some people mistake this and call this the H-4 EAD. It is not. It's its own separate EAD. It's called the I-765V. You can get up to 4 years of work authorization, and the advantage of the I-765V is that it gives people a chance to maybe plan and make a choice to leave that abusive relationship, and it does not require police certification. The I-751 waiver is also another thing that's available for people who are in marriages for less than 2 years. They can get a waiver from the joint filing requirement. And then finally, there is actually asylum that somebody can pursue gender-based asylum. This has become harder, but it is a possibility. These are the affirmative protections that U.S. immigration law offers, but that's not where we always end, right? Because some of those protections, while they are available, they can take years to obtain. And so when you're evaluating what's available for your clients, well, you want to be thinking about what are the other ways that they can maintain their status. So immigration status, where they're dependent on the abuser for their status, you have to figure out a way, can you get them on an independent status? Because unfortunately, if they're, let's say, in divorce proceedings, when that marriage terminates, they can no longer rely on their spouse for their immigration status. So I'm usually looking at ways for how can we get them onto their own independent status? And so we start exploring what are those possibilities. So for example, many times people are quite educated in their own right, even though they may have come to the United States on an H-4 dependent status. they might actually be able to get their own non-immigrant visa, like through the H-1B program. There's another possibility is maybe they often encourage my clients to go back to school, even if it's just part-time, perhaps even at a community college. They have to have the intentions of being a student, but I usually have them consider this, especially let's say English language is challenging for them. They could even enroll part-time for an English class, ESL. And these are ways to put them back in status as well as help them gain some skills back. It's interesting to me that when people think about immigration rights for survivors, they're so often thinking about the previous slide I showed you, but not thinking about the practical side, which is, well, how do we get status today? And that's where I start looking at these other options for maintaining their status, like such as getting on their own work visa, going back to school, or even just changing to the visitor visa so they can maintain their status in the US while they are fighting for their rights in a family court. Go ahead, Zakia, did you want to have any questions about that? Or
I just have a follow-up question on some of the options that we saw before, and specifically the H4, the employment authorization 765V that you were talking about, Kalpana. What
Yeah.
happens to that when somebody is no longer on H4 status? Can they still work on that EAD?
On the I-765B? Yes, they can. So the requirement is when they enter, they must have last entered the United States in the qualifying category. So they must have entered the US on an H4, but they can, if they fall out of that status, they're still eligible for the I-765B. They're even eligible up until 2 years after if the marriage terminates in divorce, they're still eligible for that work authorization for 2 years beyond that. So after the marriage terminates, the H4 status has ended, but they still can get the I-765V.
Thank you. And that can apply even if they have no other status parallelly going on.
Yeah, in fact, I mean, you don't have to be in status to have an I-765V. You're not actually going to be given immigration status at the same time, but you are considered in some, potentially in an authorized stay. That's to be debated, but you're not in status, and it doesn't matter what your underlying status is. It's just as long as you last entered the United States on the qualifying status, for example, of H4, then you're eligible for the I-765V.
Thank you, Kalpana. So maybe this is a in depth for some of these categories. So I'll first again go to the H4 visa status. When I first came to this country, I was in that immigration status, and I know that it can really feel very suffocating. You cannot work. You cannot do certain things that you want to do independently. You are financially completely dependent, and in many other ways also you are tied with the person that actually holds that visa. So tell us a little bit more about the H4 status, and when they are going through this abusive relationship, what are the options they can have, and what do you tell them? How do you help them?
Sure. So I think the thing is with the H4, it's complicated because work authorization is not often there unless the principal applicant has reached certain stages in US immigration law where they have an I-140 and you can get an EAD. So what I'm looking at usually is how to get them onto their own independent status, which is what I mentioned. And I threw up here this slide because this is sort of a common scenario that I see, at least I used to see a lot in my practice. And that's where somebody's in that H4 dependent status, and maybe they're I mean, often, sometimes it's a tactic by the abusive spouse, which is that they did not help their, the H4 dependent spouse file for their renewal of their status. They purposefully did not do that so that they're actually out of status. And then the H4 dependent is not even aware about what their status actually is. So this happens a lot because they don't have access to their documents. So we start looking at what are the, how can we first get them back into status? How can we get them into work authorization? And how do we look at getting them onto a new status? So when somebody says, oh, okay, I've lost my status, I don't know, my husband didn't reapply, that's not the end of the road. So we first look at, like, how do you regain your status? And there's this nice phrase here I've written on the screen called a nunc pro tunc request. It's not, I'm not trying to speak in another language purposefully. It's the Latin for basically asking to put your status, restore a person's status. And it's done in the course of applying for that H4 application. The applicant, hopefully with the help of an attorney, can ask for their status to be regained and show that there were extraordinary circumstances for why they lost their status. That extraordinary circumstance includes domestic violence, okay? So there's domestic abuse in that relationship. The applicant can explain that they lost their status because their spouse would not either provide them their documents, did not inform them about what their status was. So we write to USCIS and say, please restore that status because of what happened. Remarkably, USCIS often grants that request. Once we have that status restored, or simultaneously, too, we can even apply for the H4 EAD if their spouse has the I-140. But we may not know whether the spouse has the I-140. So we would still apply and ask USCIS to check its own records, okay? Simultaneously, we can apply for the I-765V that we mentioned, Zakia, because that allows us to get work authorization regardless of whether they're in H4 status or not. So these on the left-hand side of this slide, these are ways to try to address the immediate need. Now we can plan for some other opportunities. So if we can regain the status of H4, then we can apply for a change of status as well. I sometimes apply for those applications together so that we're asking them, USCIS, to regain the status and then allow my client to change their status. And then they would go to one of those other options that we described in the prior slides, like an F1, an H1, even on visitor visa. Then U visa takes time because we have to get that law enforcement certification. So, which is why if we do 1, 2, 3, and 4, while those are all happening, then we can apply for the U visa as sort of a longer term strategy. The very unfortunate fact is U visas are extremely backlogged by about 6 years. So your client's not going to get that U visa right away, right? So the visa availability is about 6 years out. Now you can get something called a bona fide determination. And if USCIS issues that bona fide determination, meaning that they believe the case would likely succeed in the future, then they can issue an EAD as well. So when you're applying for the U visa, it's important to apply for the U visa application as well as the employment authorization document. And as I've mentioned a couple times, you don't have to have a police certification, though it's helpful if you have a hearing on the domestic violence in the family court you can ask the family court judge to issue the certification. This last strategy here is about delaying family court proceedings themselves, because an H4 dependent is dependent on their status by their spouse. The termination ends that status, not the initiation of the divorce proceedings, but the termination, the marital status termination ends it. So what you can do is try to ask the family court to delay the issuance of the marital status termination while your client is trying to get into status and pursue these other opportunities. They can't delay it forever. They cannot delay it for the 6 years that it takes to get a U visa, which is why it's important to look at other opportunities.
Thank you, Kalpana. This is very helpful, especially the bit that you mentioned about the U visa, because we see a lot of organizations, and even when you go to the law enforcement for any reason, or even in the family court, everybody kind of talks about U visa. But as an attorney, you appreciate the length of time somebody has to wait. And also the stringent requirement of getting that certification in time and kind of wait to get an employment authorization. So that might not be the best case scenario for somebody who may actually look at some other benefits that can be faster to give somebody work authorization.
Yeah, and I mean, I want to say here, this is not a criticism of the pro bono agencies, but a lot of the pro bono organizations that support survivors, they have funding, right, for filing for U visas or filing for VAWA. These other strategies, they don't either have funding or they don't really have that actual knowledge to know how to do these kinds of applications. So it's really, on the one hand, while it's great to be able to get the support of an agency that can file the U visa, that's really on the back burner. It's really a kind of a backup option. The client needs to explore these other opportunities, and that's why I put this up here so that people can think about, when we're not going to just simply send them to some agency to get a U visa, but maybe there's some other areas that they can explore.
I wanted to ask a related question that no matter what benefit somebody is planning to apply, they would need supporting documentation, right? For an H4 person, they might need the original approval of the H1 visa and whatnot. And as we see that many times these documents becomes the tool for abuse, not sharing any documentation at all. So what would you say, how do we get hold of these documents? Or if we cannot get hold of them, what are the other things we can do?
You see this slide here, taking control by getting back documents. So up until, this time, right, many times clients, they don't have their documents, and they don't believe there's any way to get their documents back. And then their spouse files for divorce. The family court is actually a great ally for getting your documents back, because if the judge is made aware that documents have been withheld, you can actually ask the judge to order them to be given back to the client. Another thing is they can ask for them. So first off, you can ask for them in the family court proceeding through a document request, which is what a family law attorney can ask on the client's behalf, is to turn over certain documents. And then you can ask the court to order. The attorney can actually seek a subpoena against the husband's employer, asking them to issue those documents. And this is the part I really like, which is this bit of knowledge, is that when a company attorney files an H-1B petition, the H-1B beneficiary is actually not a party to that petition. So the company represents the employer. They don't represent the H-1B holder, right? But when they file the H-4 application, the company attorney actually represents the H-4 applicant, right? The H-4 petitioner. So even though the H-4 may not have ever had any relationship with that company lawyer, that lawyer actually represents them. And so this is the H-4 dependent can actually contact the company attorney and ask for their documents, whatever documents they may have had. So what's interesting here, right? So many times what happens is the H-1B comes home and says, okay, I need your documents signed here. Give me your passport, right? Sign this document. And they take it and they're then going to go have the company lawyer file the H-4 extension or H-4 application. And that H-4 does not have any relationship with the lawyer, but they actually do legally. And so this is a chance for them they can just contact the company lawyer. So you filed this case for me. I need my documents. And interestingly, the company lawyer has to give it to the H-4. But if the H-1B calls them up and said, you filed this case for me, please give me the documents, they don't give anything to the H-1B because they actually don't represent the H-1B. They represent the H-4 only. So I always think that's a great opportunity to take control by getting the documents back directly from the company lawyer. We also have some other things here, which is the Freedom of Information Act. You can actually request documents under that. And then you can actually ask USCIS to review its own files. If you don't have that information, you can ask them to look it up and provide whatever details you have about the H-1B holder to see if they won't give you the documents, but if you're relying on an I-140 approval, there's a potential that USCIS can at least review its files to see that and recognize that one has been filed.
Great. I think this is very helpful for us to know as advocates when somebody is coming in and has left without taking anything from the home. There are still few things that we can do to help this person.
So in terms of, on that same note, we were talking about documents and how to take control. Zakia, can you speak maybe to what the rights are of your clients with respect to, under our own Constitution? What rights do they have?
Thank you, Kalpana. Before I go into that, I'll just request everybody that if you have any questions, please write down in the chat. After the presentation is over, we'll try to get to it. If we cannot, we will send some responses to you with the slides after the training is over. So please feel free to write down your questions, and at the end, we may take a couple depending on the timing. So in terms of know your rights, as we see, and I'm sure Kalpana also sees it a lot as an attorney, that one of the fears that stops immigrant survivors from seeking help is because they're not sure whether their call will be returned. And when an immigrant comes into a new country, they don't know what rights, they may not know what rights can apply to them, and misinformation from the other party that is harming them can actually make the things worse. So very important for us to focus on this kind of know your rights opportunities, both for our survivors and also for our communities in general, that whoever is in the United States, all of the rights guaranteed in Bill of Rights will apply to them. The due process, people have the right to have an attorney, people have the right to remain silent when they need to. And we saw this going around a lot in terms of information when there were a lot of stories coming out that the ICE was, picking up undocumented people from when they're going to drop off their kids to school to their coming to the courthouses and literally taking people to deport. So at that time, we found ourselves doing a lot of these know your rights kind of sessions with our survivors, as well as our community members, telling them, you don't have to share your immigration status with anybody. You may refuse to answer any question if you're not comfortable, or you want an attorney present when you are talking to an official. So keeping those in mind, reached out only for domestic violence related services may also benefit from this kind of information, that what rights they have in general as a person in the United States. Same with right with law enforcement involvement. Somebody calls the police and they have to interact with the police. What are the rights that this person has? Can they refuse when a subpoena has been sent, that you have to go to court and you have to testify against somebody? What do they do? Is this going to be affecting their immigration status? Is this going to be putting them in any kind of wrong footing with the system in general? Right to seek safety. Anybody who needs intervention from police or other agencies in crisis situations, they have the right to get that safety. Does not matter what immigration status they may be. Right to public benefits. Most of the immigrant categories are eligible for some kinds of public benefits, either before the application or even when they have applied, they have a receipt notice. So understanding all of this in general, because immigration is a federal matter. So there are many federal rights. And then in your state, there may be certain different rights for immigrant survivors. In your county, the county may have certain rights given to survivors or immigrants. So knowing about those things and informing our clients and the general community, I think that's a big part of working with these intersections.
Thanks for that explanation, Zakia. That's great. So we're about 15 minutes before we're done. We wanted to talk briefly about working with lawyers and what advocates can do. So maybe why don't we focus on the most important aspect of it, which is how
Yes.
you prepare your clients.
Absolutely. So many times as advocates, we find ourselves working with the attorneys to file their applications. It could be to minimize the cost. It could also be because many immigration attorneys are not necessarily trauma informed. They may not have the domestic violence training to work with traumatized survivors. They may not be culturally responsive. So it's very important for advocates to work closely with clients, especially when they're drafting their statement. That is the main ingredient, if I may use that word, for any kind of immigration applications. And as domestic violence advocates, we have to be very mindful about whether this statement is bringing us to argue the case, as well as if the statement can also bring out the additional challenges that this person is facing in the future, or the healing process they may have gone through. So that is why at our agency, and I believe in most other agencies, we let our survivors know that a therapist is a very good place for them to get support, emotional support. Together with our peer counseling, therapists are very important, not just for the healing process, also because the therapist letter can be very helpful in the immigration applications.
Absolutely.
Third, the other point I want to mention is the language access. We know that only California has so many different languages. So all around the nation, there are so many different languages that immigrants speak. So when we are doing the statement, is it beneficial for us to find an interpreter or a translator for the survivor to be able to express themselves completely and in a meaningful way. So these are some of the issues that I wanted to bring out. And Kalpana, because we don't have too much time, I want to go to you and request you to talk to us about what are the expectations from attorneys when we are sending our survivors to work with someone. What should they be look out for?
Thanks, Zakia. So I'll be very quick here. I think the main thing I'm always disappointed in knowing is that some of my colleagues don't provide a written legal services agreement on services for immigration, and I think that that's something that they should demand, so that they know what to expect, right? And to understand what the strategy of the case is, what the timeline is for filing, and having access to all their documents. Very recently, I attended a vigil where Maitri was present, and somebody had walked up to me and told me they're filing an H4 EAD for me, and I wasn't clear that person knew what type of an actual EAD and whether any other applications were being filed. And I think it's critical because it is confusing, right? Immigration law is confusing. I think it's critical that somebody should have actual details about what the lawyer is planning to do, and it's not sufficient for the lawyer to say, I'll take care of it, don't worry. I'll take care of it, don't worry. That is not useful. So that's one thing I want to just say here is lawyers has to have a legal service agreement. They must give all the invoices. You get the file belongs to the client. They should have access to the legal file, and they should receive all the documents that are filed on their behalf and that are received on their behalf. Just the basics. I think that part, if we can ensure clients have that, then they are in a better position to be able to continue to advocate for themselves. And I always feel strongly that by the time somebody comes to see an attorney, they actually are wanting to advocate for themselves. And so what we can do is support them by knowing what they're supposed to be able to demand. So in the 10 minutes that we have left, I think we wanted to open it up to some Q&A. And I will stop my share so that we can see each other more fully.
Yes, so I see there are two questions. The first question is about a very specific situation. Dilip, probably this would be a good answer in an email. And the second question is about VAWA. How long it takes for the applicant to get the work permit, and what to do if they have been waiting for more than 6 months?
I haven't looked up the timelines on VAWA. Sorry about that. But if they've been waiting for more than 6 months at this stage, I'm afraid I don't think that that's unusual. You can always make an expedite request, Amina. So that's a possibility.
What's an expedite request? What is it?
So basically, you would send a written request to USCIS, identifying the case number and stating the urgency for why the work permit should be issued. But unfortunately, for quite some time, many of these requests have been ignored because USCIS is so backlogged. But that's really the only recourse that you have.
Okay.
There are other recourses that are beyond the conversation for today, but that's in the realm of federal litigation, which is something I have done for my clients where we think that cases are stuck and moving too slow. There is a method through federal litigation.
Okay. Can you explain one of them, like these methods?
Yeah, that's way beyond today. So
okay.
Maybe we can send you some links, Kalpana.
Yeah, it's just a strategy that attorneys have been adopting, which is to sue in federal court. And then what happens is the U.S. Attorney's Office contacts the lawyer and will potentially work out a settlement. And this is a way to expedite cases.
Uh-huh.
6 months wait on a VAWA application probably doesn't rise to the level of seeking that type of
Uh-huh.
remedy. And this is a complicated remedy for which a lawyer would have to do the filing.
Okay, got it. Thank you.
Yes, so I also want to address the first question, which may not be answered right now, but it brings out a very interesting point that when survivors are reaching out, they may actually have different types of benefits that may come along the way while they are waiting. So this is a situation when Dilip has written that a single female who is on F1 is being subjected to sexual harassment by store owner employer, where she's working, under the table, but she's afraid of doing this. Now, of course, there are many different layers to it, but even domestic violence survivors can be eligible for other types of remedies, like if they are experiencing labor trafficking, they're experiencing sex trafficking, depending on the complete complete facts and all of that, there can be an assessment done. So hopefully when we share some resources, you can refer this person for an immigration assessment on her situation. Okay. All right. I don't see any other questions. Anybody has anything else? Okay, I think we're good.
Okay.
There's a few people that raised their hands. Shabana, did you have a question?
Just quickly checking, you mentioned about the H4 dependent working with the actually the company attorney is actually representing. So there should be an agreement so that they are actually representing the H4, because most of the clients that our survivors that we have connected, they do not know. They always say that, oh, we cannot disclose anything with you because we are actually representing the H1B spouse. So
there's never, unfortunately, those agreements are not typically written. There are no, most lawyers don't have an agreement with the H4. It was a practice of my firm, but I would say 95% of the firms don't do that. The H1B employer's attorney does not represent the H1B holder, period. They don't, unless they had a separate agreement they entered into. They are representing the H4. So the moment that the lawyer puts a G28 form in, that meant that they are representing the H4. So that attorney just may need to be reminded of their obligation. And you can even say that to the lawyer. The G28 meant that you are representing them.
I think Rakia had her hand up. Did you want to ask?
Yes, yeah. I just want to know when we have clients that they are going through domestic violence and they have problem with their paper, like some clients, they have the partner doesn't have maybe good income. For some reason, they have sponsored. And then when they leave that relationship, it's so hard to get for them any kind of like public benefits, because they ask to bring this the income of the sponsor, and most of the time the sponsor is the family of the abuser, and as a domestic violence we can't reach out. So is there any solution for those people, because they don't speak English, they still has to go for ESL, they can't work, and their green card is on process. So even if they have temporary green card, it's hard for us to give them any kind of benefit because of there is a sponsor.
So Kalpana, if I may share one of the similar experiences that we have had clients with conditional green cards where there is a sponsor taking responsibility for finances, and what happens when they're actually trying to separate and they go to the public benefits office. And here, oh, by the way, your sponsor is supposed to be providing you. So we have been in the past been successful in getting a domestic violence waiver, arguing that there is a domestic violence in the situation. And this can be easier if this person has either a restraining order or staying at a safe location to show that proof that this person had to separate due to domestic violence and needs the help. Many times it has worked for us. So you can reach out and we can probably talk more on this situation.
Okay,
Yeah.
thank you. Thank you.
Okay, I think we don't have anything else. Kalpana, last words.
Last words. Okay. So we're trying to cover a lot. It's hard to teach immigration law, and also the dynamics with domestic violence in less than an hour. Probably hard to do that even in 3 more hours. The main thing, I think our goal was for you all to be aware that there are affirmative applications that are available in the US immigration system, but also to, when you're planning these days, you have to plan what are the other ways that you can work with this system, because our immigration system is so backlogged for these different petitions, you know, whether it's a VAWA, a U visa, I-765E, anything else. So finding other short-term solutions is critical. That's one thing I just want to make sure people start thinking about, and being aware when you visit with lawyers that they should also be thinking about that as well.
Yeah, that's wonderful. Kalpana, I just want to add with you from an advocate's perspective that we don't have to be experts in everything. There
That's
are
right.
experts around us. There are agencies, individuals, and so many resources that are available today for domestic violence advocates, survivors, and whoever wants to learn more. I think we just need to have access to those resources and set out some time to continue to learn and not get really just bogged down in crisis intervention, right? Putting out the fire, that is very important. But at the same time, we need to know about what are the new things that are coming up in this movement and how better we can help our survivors.
Well, Zakia, thanks for all the work that you do. And I know that you've spent a lot of time learning the intricacies of US immigration law as well. And that's a tremendous benefit to all of your clients.
Thank you, of you. And we appreciate the help that we get from attorneys like Kalpana and many other attorneys around us that are available whenever we have any questions. So I would say, find who is in your area willing to help you devise a strategy for your cases. Okay.
Thanks, everybody. Take care.
Thank you. Bye.
Bye.